E-commerce brand owners, did you know that you can boost your brand value by having IP protection? We're going to talk about that in this episode of E-commerce Revamped.
Welcome to E-commerce Revamped, where we break down the hottest trends, insider tips, and strategies shaping the future of e-commerce. Powered by Meta, the engine behind seamless online stores. Now here's your host, Rob Stanley.
Hey everyone, welcome to another episode of E-commerce Revamped. I'm your host, Rob Stanley. I got a great one today. We're going to be talking about how to boost e-commerce brand values with intellectual property protection. That is a lot of words to say. And the good thing is I have just the expert. We're going to have Rich Goldstein come on into the studio here. What's going on, Rich?
Hey Rob, how you doing?
I'm doing great. Listen, I've known Rich a long time and I've seen him at tons of events. I've watched him speak. The guy knows this shit. I'm just going to be straight up honest with everybody. He knows what he's talking about. This is definitely the guy you want to learn from and listen to. So that's kind of a bold statement about increasing your brand value with intellectual property protection. Rich, start us off with what's the first thing people should do to boost their brand? Do they need an IP or should they see if they have one? What do we do first?
Well, I think the first thing is to have a strategy for how to use IP to boost your brand value. And it's going to depend tremendously on what type of products you sell, what you've, in other words, do you have differentiated products? Are you white labeling? Are you simply sourcing products that already exist? And you're just rebranding them or selling them under your brand through e-com channels. So it kind of depends on what differentiates you, where we would begin with protection. But I'll say one thing, that is, if you do have a brand, meaning a brand name or a logo, you have things that you're using to differentiate your store from others, then it's a no-brainer to file trademarks on that. So in as much as I would say we start with figuring out what is the right types of IP for your business, I will say that protecting your actual branding, your brand name, is a no-brainer. So we start there.
Yeah, absolutely. So I was just going to ask you, and you already kind of covered one of them. I was going to ask you, what e-commerce seller assets should they protect? Give a little list of some of the things, most common things that e-commerce sellers should protect when it comes to their brand.
Okay, well, I mean, first of all, the brand name is number one for two reasons. One, because it's there's a tremendous amount of value that you build into your brand. Every investment you make into getting people to know of your brand, whether it's pay-per-click advertising or any other type of marketing or promotion you do for your brand, the way you protect the integrity with that brand recognition is through having trademark protection. So certainly number one on the list is protecting the product name, the brand name. Beyond that, it's a matter of kind of what you have that's distinctive and where you're going to get the most bang for your buck. So if you have a product that is unique in its functionality and not just unique in a small way, in other words, there are other people that have products like that, but maybe you've made a little variation to it. But if it's unique in a groundbreaking way, where you've got some really solid innovation to the product itself, then you need to be patenting that. So that would be a very high priority. Beyond that, if you have a product that has a unique appearance, then you can protect that with design patents. And design patents are a very useful tool on e-com platforms because most of the time when people copy you, they just make a product that looks similar, and that would infringe a design patent. So if you're working through a platform like Amazon, then you can use their enforcement mechanisms to shut down competitors. You don't even need to go to court or do anything like that. And the same goes with other platforms like Walmart and Walmart, eBay, even Alibaba. They have mechanisms in place to help you to enforce your IP. So that would be pretty high priority. I'll
Yeah,
just say
absolutely.
a couple more things about the brand protection. So, like I said, the highest priority in terms of what you protect with your branding is the name. If you've got a distinctive logo, that also is a priority, not as high. And then moving further down the line, if you want to maximize what you have with IP, like get as much IP as you can, which I'm sure we'll talk about in a little bit why we do that, then you look toward things like ingredient names. So you have a unique name for an ingredient in your supplement, that could be a trademark. You have the slogan that you use, that could be a trademark. So it kind of goes like that in terms of priority order, but essentially the beginning of all of that is taking a good look at what you're doing with the brand that you're building, with the company that you're building, and where are the best leverage points for IP, and that's IP strategy.
Absolutely. Absolutely, Rich. I appreciate that. For e-commerce sellers, either currently selling or getting ready to start selling, when is the appropriate time to register a trademark? Just kind of backing up to trademarks again.
Yeah, I mean, I think the appropriate time is before you launch, and there are some pros and cons to filing a trademark application before you launch, but I think the really the critical thing is that you have the research done into the brand before you get too far into the development of the product, because it's like if we do a trademark search and we figure out that this brand is not going to be protectable, it might be a good time to pivot before you spend too much on developing the product or even having it manufactured and packaged, only to find out that either the brand is not protectable or you might actually be in conflict with someone else's trademark rights. So it pays to do it at an early stage for that reason alone. And then also the process gets much more expensive if someone happens to file their trademark application before yours. So, what is perhaps a $2,000 to $3,000 trademark registration process could become more like $50,000 if someone else files before you, and you have to oppose their trademark or move to cancel their trademark. Because if someone files before you, you would need to handle their application before you could even get yours through. So, it pays to do it at an early stage.
Yeah, absolutely. Sometimes people get caught up. They're trying to get that business going, that e-commerce business going. They don't even know if it's going to be successful. But just in case, you need to get that trademark in. Absolutely, appreciate that, Rich. So we're talking a lot of words here that maybe some newer e-commerce sellers are not aware of, and maybe they're not aware of what they mean. So I'm going to throw three at you, Rich, and if you could just explain the differences between the three, and also explain what they are for. And we covered a couple of them here, but maybe between patent, trademark, and copyright, if you could help out everybody out a little bit on what those are and how to use them, basically.
Absolutely, Rob. So first of all, if you're talking about what makes a product different, like functionally, in terms of the appearance of the product, then you're likely talking about a patent. Patent is how we protect patent law is how we protect improvements in the functionality of the product, in the structure of the product, and also in the appearance. So those things are protected with patents. Trademarks are about branding. Trademarks are about the things that set your business apart in the marketplace, such that when people see them um, by a competitor, they might be confused. And let me just explain that for a moment. It's kind of like if you think about Nike. Nike has the name Nike, that's a trademark. There's also the swoosh symbol, that's a Nike trademark. And there's also the phrase, just do it. So it's kind of like if you saw any of those things on a box of sneakers, you would immediately assume it was associated with Nike. So if you saw a box of sneakers that said, just do it on it, you'd be like, oh, those must be Nike sneakers. So if a competitor did that, then that's creating what's called a likelihood of confusion. So when someone is confusing the public or creating a likelihood of confusion with your trademarks, then that's something you can go after with trademark infringement. So use trademark to protect your branding, And then copyright is for content. So whether that's the images on your listings, or that's a musical composition, or a video, the content is what gets protected with copyright. So when you think of copyrights, think content. When you think of patents, think the difference in the product, what makes the product itself special. And when you think of trademarks, it protects the branding. So that's probably the best way to break down what the three are all about.
Excellent. Excellent. So us doing this podcast, is this automatically copyrighted, Rich? Just curious.
Yes. So basically the way copyright law works is that once a work is fixed in a tangible form, then it's protected by copyright. Fixed in a tangible form means that Rob hit record, and what we're saying here, the video and the audio is being recorded. It's being fixed in a tangible form. Then that's now eligible for copyright protection. Or if you take the novel that's in your head and you write it down through your word processing software, then you are fixing it in a tangible form. Went from an idea in your head to something that's actually concrete. That's now copyright protected. And the thing is, so works of content are technically protected from the moment that they're fixed in a tangible form, but it pays to register your copyright for anything that's important to you. It's a fairly simple process. You file a form with the Library of Congress or the U.S. Copyright Office, basically two names for the same thing. And essentially, once the copyright is granted, then you have proof of the copyright. And on certain types of enforcement action will require you to have a registered copyright. Generally, to file a court action, in other words, to actually file a lawsuit, you need to have the copyright registered. And also, when you're looking to do enforcement through platforms like Amazon, Walmart, etc., they will look for a registered copyright as well.
Excellent. Excellent. That's good to know. Rich, I'm going to switch subjects a little bit here, but before we do that, we're going to take a quick commercial break. When we come back, though, I want to talk to you a little bit about NDAs, what they are, when to use them, and we're going to do that right after this commercial break.
Need an e-commerce platform that's as ambitious as you are? Miva empowers your business with seamless design, top-tier features, and the flexibility to scale. For serious growth and a better online experience, it's got to be Miva. Visit miva.com/podcast and start building success today.
Be sure to head on over to miva.com/podcast. We are having that redone right now, or depending if you're listening to this later, we're going to have some really cool content on there. All the different podcasts that we've been doing, all the different downloadables and resources. But I have Rich Goldstein on right now, and we're talking about how to boost e-commerce brand value with IP protection. And Rich, right before the break, I was asking you about NDAs. So how do NDAs safeguard e-commerce innovations?
Yeah, so NDAs are interesting because in a certain sense, it's a false sense of security for someone who really relies on it. So all an NDA is, well, by the way, NDA stands for non-disclosure agreement. All an NDA is a contract. It's a contract where someone is promising you not to reveal the information that you are showing to them. So essentially, it's like if you were going to, if you're working with someone like let's say it's a coaching engagement, and you're working with a company that has certain technology, they might have you sign an NDA where you promise that anything that you learn during this coaching engagement, you're not going to reveal. So essentially an NDA is just a contract, though, which means that it's only effective against the people that signed it. So an NDA doesn't protect an idea against the entire world. It's just really protecting you through contract law against having the person who signed it disclose the information. So it's not a suitable way to protect the product, which is first, because anything that's out there in the open, like you put your product online, it's not confidential. There is no NDA with the people that review your product on a website. So essentially, it's not effective at protecting a product itself. But again, it is good for protecting the more limited information that you provide to people. At the same time, though, an NDA is difficult to enforce. Let's say if you do reveal it to someone, let's say you're working with someone on building your product, they're helping you to build prototypes of your product, and they sign an NDA. Well, if you see that product out there on the market the following year, you can't go after that person that you engaged to build a prototype unless you could prove that that product out there in the market is a direct result of the person who signed the NDA violating their agreement to keep it confidential. So it's rather difficult to enforce NDAs for that reason, because you can't prove how the information got out there. But I'll tell you what I think NDAs are good for, is I think that they help keep honest people honest. And what I mean by that is, like, let's imagine that you're working with a certain company on helping you to develop aspects of your product, and they've signed an NDA. Now, they probably don't intend to do you harm. Like, they're not looking to steal your idea. They're not looking to get around you. But if you sign if you enter an NDA with them, they'll think twice about maybe blabbing about your idea. So imagine that you're meeting with them in the morning, and they go out to lunch with some friends, and the friends like, hey, you seen anything interesting recently? And without an NDA, they might be like, oh yeah, I had a guy come in this morning that showed me this product with X, Y, and Z. Not trying to do you harm, but just because, like, they're gossiping, they're just making interesting conversation. But when an honest person signs an NDA, it reminds them, oh, this is confidential. I shouldn't tell just anyone about it. I shouldn't make casual conversation about this person's idea, because we entered into this confidential relationship through an NDA. So in sum, I think that NDAs are useful to help keep honest people honest. It just reminds people that it's supposed to be confidential information.
Absolutely. And I always advise everybody, before you sign an NDA, first of all, read it. And second of all, have a lawyer look at it, which is probably not a bad idea. Rich, when I was doing a little research on some questions to ask you, I came across a question. I didn't quite know the answer. I had to go look it up, but I'm sure if I came across it, others will too. What is trade dress and why protect it?
Okay, so trade dress is a form of trademark law. So trade dress, remember we talked about trademarks pertaining to things like the name Nike, the the logo, or the kind of the swoosh symbol, and the slogan, just do it. So those are different things that are protectable on the trademark law from consumer confusion. Now, trade dress is an extension of that. So trade dress is specifically pertaining to how you present the product. And it could be about the product design itself. It could also be about how you advertise the product. So it's things like the color scheme that you use. It could be kind of like, you talk about sneakers. It could be kind of like that familiar design of Converse sneakers, right? That when you see it, you say, oh, that's Converse. So trade dress are aspects of the product itself, or the way in which the product is advertised, that really evoke for the consumer the idea that it's coming from one particular source, from one particular company. So there are times when it's an effective way to prevent people from ripping you off by protecting your trade dress.
Nice. That's what I ended up looking up. So I did not know the answer to that question. I had to look it up.
I get it right. I was just
No, that was good. That was, of course, I found a shorter version, but that's okay. Everybody
Right.
needs a better explanation of it. It's not an easy answer.
Yeah, and
So,
sometimes
Rich,
lawyers can't help but just keep talking.
that's okay. That's why you and I are perfect together, because we talk a lot. I'm going to switch back over to IPs more, and we're going to, as we kind of finish up towards the end here, we still got a little time left. But how does IP protection deter counterfeiters, and how can you monitor your IP for infringements?
Yeah, well, I mean, in general, when people see that something's protected, when people see that you've got a patent or you have a trademark, or you have copyright protection, they think twice about copying it. So if someone is trolling through kind of various tools to see what products are out there and are doing well, they're looking for a product to copy. Well, when they see that it's protected by patent, they are more likely to think twice. Like, there are always people that will copy it no matter what, but I would tend to think, or just been my theory throughout my career, that about 80% of people are deterred by the presence of a copyright, of a patent, a trademark, and even when something says patent pending, which means that a patent is in progress. So even though you don't actually have the patent, it tends to keep most people away. So I think that's it's a reasonable way to stop counterfeiters, is just through that psychological deterrence, just through the fact that they realize that it might be better for us to just look at some other products that don't have IP protection.
Yeah, I love that. That's perfect. Rich, looping back around. Good.
What was the second part of the question? I think I missed.
The second part of the question was that regarding how can you monitor your IP to see if somebody's infringing it.
Yeah, well, there are various tools online that there are various tools that you could use that look online and do searches for text and for images that might lead to IP infringement, and there are also various service providers that have such services where they are offering to monitor competitors for potential infringement. So that's something which, I mean, I haven't personally used any of those tools. But one thing to understand about this is that as the IP owner, it's on you to determine this. There's no one else that's looking out for infringement of your brand or infringement of your patent. So you need to police it. And I'll say one thing is that, like, you could you could be kind of neglectful in enforcing your patent, and it's not that big a deal, in the sense that you might be losing out on money, but it's not going to dilute your patent rights. But when it comes to trademarks, it's extremely important to police your brand. So it's like, if someone is copying your mark, someone has a business in your field with a similar name as your trademark, and you don't go after them, over time, you're going to dilute the value of your trademark. You're going to dilute the integrity of your brand, because people will start to get confused between the two brands, between yours and theirs. And so over time, it's going to make your brand that much less distinctive. Imagine if lots of sneakers used the swoosh symbol next to it and Nike didn't go after them. Over time, when people saw the swoosh, they wouldn't necessarily know that it was Nike. They would be like, oh, it could be Nike, but it could be one of those knockoffs too. So that's a bad situation. So you want to make sure you nip that in the bud. If someone is infringing your trademark, it is really important that you go after them, that you enforce it, that you maintain the integrity of your brand, because otherwise you're going to be cutting away at the value of your brand, and ultimately against the exit value of your company.
I'm glad you brought up exit value, because that leads right into my next question. So e-commerce sellers go out, they get this IP, basically protection, or they get their IP. So how is getting the IP increasing their brand value? Kind of explain that.
Yeah. So anytime that you're exiting a business, you typically be looking um, at a valuation, right? And that valuation comes most likely from your EBITDA, which is like a fancy word for your yearly profit, times some multiple, like a number like 3, 4, 5, 6, some multiple. And what that multiple is going to vary from industry to industry. So sometimes you might be looking at, let's say, um, within kind of product brands or ecom product brands, maybe the range of multiples is 3.0 to 7.5. And that's typically what most acquisitions fall within. Well, if you don't have IP, you're likely going to be looking at on the lower end, say maybe a 3.0. And let's say you've got 2 million in profit in your business. Then with that 3.0, you're looking at a $6 million valuation. But now, if you've got good IP, like the type of IP that will actually stop other people from entering the market, stop other people from competing, when someone is looking to buy your brand, it makes your brand so much more attractive because they realize that not only are they buying the momentum that you've created through your product listings, they're also buying the market. And so instead of 3.0, you might be looking at twice that, like 6.0, in which case you're looking at a $12 million acquisition. So now all of a sudden, you're getting $6 million more because of your good IP. But wait, there's more. One other thing to realize. Remember, that was with good IP. But now imagine you've gotten some trademarks, maybe you got some patents, but they're not very good. It wasn't well done, wasn't well thought out. It wasn't strategic, and maybe there's not a lot of protection that you have with it. But when you go to sell, the people that are looking at acquiring you realize you've got an IP portfolio. So maybe instead of that 3.0, because you've got an IP portfolio, it makes it a little more solid, and they're willing to conservatively stretch it a bit to 3.5. But that extra 0.5 is an extra $1 million on your $2 million EBITDA, right? So instead of 6 million, now you're getting 7 million. Even though it's crappy IP, it does show that you've dotted the I's and crossed the T's, and it will increase the value enough to increase your payday by about $1 million. So three possibilities here: no IP, $6 million, kind of some IP but not really noteworthy, $7 million, good IP, $12 million. So now the last point is the difference between getting the $7 million with crappy IP and getting the $12 million with good IP. That $5 million difference is from having good IP strategy from the beginning, which means taking a look at what you have, like what you've kind of like what you're creating with this brand, what your vision is, and having the IP follow pace with what you're creating as you grow your brand.
That's excellent. Excellent information and good to know. And those are great examples. I mean, who doesn't want that extra money? I mean, that's a great,
exactly.
Yeah, I definitely would. Listen, if anybody's interested in reaching out to you, Rich, and getting a hold of you or learning a little bit more about Goldstein Patent Law, and if I missed anything that I know you guys do a lot over there at Goldstein Patent Law, feel free to cover kind of any of the other scenarios that you cover for e-commerce sellers, and then let everybody know how they reach out to you.
Okay, sounds great. So in general, you want to learn more about me or Goldstein Patent Law, you go to goldsteinpatentlaw.com. And if you want to contact us to see if it's a match to work together, you can go to clients@goldsteinpc.com, or I should say you should email clients@goldsteinpc.com. And also, so we do help e-com sellers to protect their products and brands with patents and trademarks. But one of the other things that we do is we help them with infringement situations. So either they've been unfairly accused of patent infringement, trademark infringement, or they need to carry out some enforcement. Those are some other services that we offer. And in general, I think one of the most important things is when we get involved to look at IP strategy. So take a close look at their business to see where the opportunities might be to increase their value through IP, and also where there might be some blind spots and some risks that they don't realize that they're taking that perhaps can be alleviated with the right strategy.
Absolutely. So listen, any e-commerce seller, listen to this. If you do not have a trademark, if you have a product you invented, built, and you don't have an IP on it, I would be contacting Rich immediately. Get a hold of his email his company, seriously, and schedule a call. First of all, I know a bunch of the people over there at Rich's office. They're amazing people. I've worked with them myself. I've seen them a million times, asked them lots of questions, and they know what they're doing. They know what they're talking about. And you definitely want somebody on your side who understands this and specifically understands the e-commerce business and industry, which Rich has been around for many, many years. So definitely be reaching out to him. So once again, if anybody is interested in reaching out, I know you have a couple domains. So I had goldsteinpc.com or clients at goldsteinpc.com. Yeah, either one of them will go there. Or just literally Google Goldstein Patent Law. You will definitely find it. Rich, always great having you on the podcast. Love catching up with you. Love hearing about, these tips to help e-commerce sellers and help them protect themselves, because, a lot of times they don't do this ahead of time, or it's a reactive where they get in trouble and then they react to it. And you've probably seen that yourself.
Yeah. And those problems become much more expensive as time goes on. It's like, it's amazing how they get more expensive. And just, I guess I'll footnote that with, essentially a lot of brands just put off getting their trademark protected, and then it becomes a much more difficult situation as time goes on. It just pays to do it early.
Absolutely. So save yourself some money, get that trademark done, get a hold of Rich and his team over there, and get that trademark completed. Rich, thanks again for being on the podcast. I really appreciate it. And for everybody listening, be sure to listen to the next episode. We got great guests coming on. And if you haven't heard any of the previous ones, definitely go back and listen. Thanks again, Rich. I appreciate you coming on the podcast.
I appreciate it. Thanks, Rob.
Thanks for tuning in to E-Commerce Revamped. Ready to take your e-commerce business to the next level? Visit Niva.com for the tools to build seamless online stores and unforgettable customer experiences. Until next time, keep your cart full and your customers happy.